Welcome to The Explainer. Today we're going to break down a landmark Supreme Court case that really redefined liberty in America. And believe it or not, it all started because of a bizarre and, frankly, pretty jealous phone call.
It sounds almost crazy, right? But the story of Lawrence v. Texas kicks off with exactly that. It set in motion a legal battle that would end up as one of the most significant civil rights decisions of the entire 21st century.
Okay, so here's how it all went down. It began with a totally false report. A man named Robert Eubanks, in a fit of jealousy over his partner Tyrone Garner, calls the police and makes up this story about a man with a gun. So when officers go into John Lawrence's apartment, they don't find a gun at all. What they do find is Lawrence and Garner together. And just like that, both men were arrested, not for some weapons offense, but under a Texas law that specifically criminalized private intimacy for same-sex couples.
So yeah, that's how the state got inside a private home. It was all based on a lie. Inside, the police found zero threat, just two men in a private, consensual moment. Their arrest is what set the stage for this huge legal challenge to a Texas law that only criminalized this kind of intimacy for people of the same sex.
All right, so the case eventually climbs all the way to the Supreme Court, but Lawrence and Garner were facing this massive legal roadblock. See, there was a 17-year-old decision from a case that was really similar that had upheld a state's right to have exactly this kind of law. And that case was Bowers v. Hardwick. Back in 1986, the court had ruled that the Constitution just didn't protect this kind of private activity. It basically gave states a green light to pass laws based on, moral disapproval of homosexuality. So for Lawrence and Garner to have any chance of winning, Bowers had to be overturned.
But, fast forward to 2003, and the court, it was ready for a major rethink. The majority opinion, which was written by Justice Anthony Kennedy, was built on this powerful new way of looking at a core constitutional idea, liberty.
What's really interesting is that Kennedy's argument didn't really focus on unequal treatment. Nope. Instead, he reached for a much bigger idea, liberty itself, as protected by the Due Process Clause. And this part of the Constitution, it's not just about, say, a fair trial. It also protects these fundamental freedoms we have from government interference, especially in the privacy of our own homes.
I mean, just listen to the powerful language Kennedy used here. It completely reframed the whole debate. He argued that the liberty the Constitution protects isn't just about specific acts. It's about personal dignity, autonomy, and the right for adults to make their own choices in their own homes without being branded criminals by the state.
But here's a really fascinating twist. So get this. Justice Sandra Day O'Connor, who had actually been in the majority that decided Bowers way back in '86, she agreed with the outcome here, that the Texas law was unconstitutional, but for a totally different reason. So now you've got these two totally different paths to the exact same conclusion. While Kennedy's majority opinion was all about a universal right to liberty, O'Connor's argument was that the law failed on the grounds of equality. For her, the big problem was that the law singled out just one group for punishment while letting another group engage in the very same conduct.
Of course, not everyone was on board. Justice Antonin Scalia wrote this absolutely fiery dissent, arguing that the court was radically overstepping its authority and basically inventing new rights out of thin air. His biggest issue, really, was the court just tossing out stare decisis, that core legal idea that you should stick to past decisions. He argued that overturning a 17-year-old precedent like Bowers just because the judges on the court had changed was a really dangerous move for the stability of the law. Scalia warned that this decision would basically gut a state's ability to pass any laws based on public morality. If moral disapproval isn't a good enough reason for a law, he argued, then what about laws against things like bigamy, adult incest, prostitution, or adultery? He saw the court starting down a very slippery slope. At the end of the day, Scalia was accusing the court of taking sides in a culture war. He argued it was inventing a new constitutional right and imposing its own views instead of, letting these issues be decided through the democratic process by the people's elected lawmakers. And then you have Justice Clarence Thomas, who, in his own short dissent, put it even more bluntly. He called the Texas law uncommonly silly and said that if he were a lawmaker, he'd vote to get rid of it. But, he argued, his personal opinion didn't matter. As a judge, he just couldn't find anything in the Constitution that gave the court the power to strike it down. So, when all was said and done, the final vote was 6-3. The Texas law was struck down, and with it, the 17-year-old precedent of Bowers v. Hardwick was officially wiped off the books in American law. So, okay, why does this case, a case that started with a totally fake police report, matter so much today? Well, because its impact reached far, far beyond the walls of a private bedroom.
You can actually see a straight line here in the legal reasoning. The idea of liberty, dignity, and personal autonomy that Justice Kennedy laid out in Lawrence, well, that became the foundational legal argument that just 12 years later in Obergefell v. Hodges led to the legalization of same-sex marriage across the entire country.
So the big takeaway here, really, is that Lawrence v. Texas was about so much more than just striking down one, uncommonly silly law in Texas. It fundamentally shifted the Supreme Court's whole understanding of liberty under the Constitution. It affirmed that there is a sphere of private life and personal choice where the government just can't intrude.
And this all leaves us with a really provocative question, one that comes straight from the majority opinion itself. It's a challenge, really, that makes sure the Constitution stays a living document, forcing every single generation to re-examine which of our laws truly serve justice, and which ones, well, might one day be seen only to oppress.